This is Mike Franklin, a property tax guy, and I'm going to review the lawsuit I had with City of Syracuse. I successfully sued them in New York State Supreme Court, and I'm going to show you how to look up the case, and you can review it all yourself. We're going to look it up in the New York State e-file. So just Google NYS e-file, and then e-filing e-courts. New York Unified Court System. Click on that. Then on the left side, you'll see search as a guest. Search there. And then go by name. And my name is Michael. Last name Franklin. You can look it up by attorneys and all that kind of stuff, or by the city. Ben Walsh. Let's see if what we can find here. Michael Rutan Franklin versus Ben Walsh. Click on that one, and here is the entire case, beginning to end. Look at that. There's 45 things, and the very last one is the decision. I'm going to review the decision. As you can see, Michael Franklin petitioner versus Ben Walsh as mayor for the city of Syracuse, and Matthew Oja as the assessor for the city of Syracuse in the county of Onondaga, New York. And basically, it's 7 pages long. And basically, it says that that if they had run, what I'd sued them for is I had. I'm going to go back to. I did Freedom of Information Act requests. Okay, so here's the original FOIL request, item number 3. I asked for inventory data, comparable sales report, cost report data. Request entire assessor file for the property. Request assessor's data as to how, after purchase prices assessment, how they adjusted other properties to bring them in line with the increase. They provided me with a couple old inventory cards that really had nothing to do with anything. They just provide nonsense to give the impression that they complied with the Freedom of Information Act request. But the most important thing was the comparable sales report, and they refused to provide it. Here's the mayor denial letter. This is hilarious. Signed by Ben Walsh himself. Because no records exist relating to this request, your appeal is denied. That's just a blatant lie, because obviously it did exist. All I had to do is take 2 minutes to run a report. Okay, and here's evidence that that report does in fact exist. The deputy assessor provided this at the Small Claims Assessment Review hearing, which contradicted the truthfulness of the mayor of the city of Syracuse. And, am I going to blame the mayor for being a liar? Well, his law department led him down that path. Okay, let's see. We've got another exhibit. Let's see. It's law department. Let's see. As a courtesy, upon receipt of your demand regarding the production of a comparable sales report concerning 7 Brattle Road, Department of Assessment performed a subsequent search and identified one comparable sale. So they found a report from like 12 years ago. In other words, what the city of Syracuse is saying is, if they have a physical copy in their file, they would give it to me. But no, they don't, because it's on the computer. Yeah, here's the report that they provided me. It's very disingenuous. It's from it's from 2010. They're just being ridiculous. Let's see what else we got. Okay, this is some case law. Decision in order of Eckel versus Nassau County. That is the case law that I provided, and you can read all about it if you want to. You can read the decision, but basically an individual sued Nassau County to provide the comparable sales, and they had to sue them and went to appellate level, and they were forced to provide it. And so that's the case law that I used. The City of Syracuse was using case law of General Motors versus Messina from 1998, which predated the New York State real property tax system. And in that particular case, it's an automotive parts manufacturing facility that was requesting third-party consultant data that the city had hired. It's a completely different scenario than what was going on with what I was asking. I was asking for data from the New York State real property system, and this is data that belongs to the people. It's paid for by the people. It's not some third-party consultant. And so the case law they use is just completely irrelevant. But until Eckel versus Nassau County, that was actually the only case law that existed that it was even remotely, because people just don't take these cases to Supreme Court because it doesn't make any economic sense. Okay, the request for judicial intervention. That's just a requirement. We can take a quick look at it. It's just a form you have to fill out, just a requirement. And then I did my affidavit of mailing. It's just things you have to get notarized that said that it was served. And you can take a look at that yourself. That's just something you have to do. Letter of correspondence to the judge. Let's see. Oh, the city had asked for more time, so I wrote a letter to the judge saying that the city doesn't have time to fulfill FOIL requests, and but they have time to get involved in frivolous lawsuits. By not spending 2 minutes in providing me with the reports that I request. And then the judge granted them extra time. They say that they're lacking in resources, but I looked up the pay grades that was on Syracuse.com for everybody in the legal department. There's like 20 people making all kinds of money, but they don't have time to fulfill FOIL requests and so on and so forth. Okay, so the letter from the judge saying that give them more time, even though probably shouldn't. Answer in special proceedings. Let's see. That's just the city's attorney responding to my petition. She's just denying everything. Affirmation that she'd done that. Let's see. She provided exhibits of my emails that I had sent. Let's see. Affidavit. Let's see. Oh, then an affidavit from the assessor himself, and he continued on with his disingenuous nonsense about there not being any documents in the file, and he said that the cost report, that he's never heard of such a thing, and so let's see. So I provided an exhibit. Let me see. Assessor, yeah. Can't prevail. Where is it? Well. Anyway, I provided a copy of a cost report from another municipality that I didn't have to sue to get the cost report. It completely contradicted his assertion that they didn't exist. Let's see. Let's see. She provided a memorandum of law, which, she really had nothing to support or contradict my case law. What else we got here? Letter of correspondence to the judge. Apparently she made a mistake and she's just letting the court know. If David, more exhibits. Oh yeah, here's the cost report I was telling you about that the assessor said doesn't exist. So the assessor lies about the cost report, and the mayor lies about the comparable sales report not existing. It's hilarious. Let's see. So here's my memorandum of law, and basically, I took a lot of the concepts from the Eckel versus the Nassau County case, and there's just a lot of good stuff in there. Such as the city. There's supposed to be provisions that the city can't just say sue you. What else? If the city, if the data is in a database format, if it doesn't require too much effort, they have to provide it, and things of that nature. Let's see. I mean these things are kind of extensive. All these arguments. Spent a lot of time putting this together, but it just goes through the entire argument. And you know what? I really appreciate the judge being able to go through all this stuff, because this was really a simple argument, but the city wanted to make it complicated. So it kind of, I would think the judge would be overwhelmed by all of this stuff, but he did a great job of breaking it down to the relevant elements. Let's see what we have here. Yep, the assessor's comparable sales report that they claimed didn't exist. Her letters of correspondence. Let's see. Back and forth. More exhibits. But let's see. Letter of correspondence. Yeah, so she wrote a letter of correspondence. Let me see what she said here. The petition, Article 78, concerning city's response to is not the proper venue to address unrelated complaints to, in his recent letter pertaining especially regarding the dates of file requests. The petitioner's blanket request for order directing fulfillment. Well, the judge did not. So I had asked for an injunction moving forward when I request data that the court order them to comply. He didn't give me that, and I can appreciate why. That's just kind of overly broad. But the fact that that he had established that they had to give me this, will cover me requesting in the future. So I wrote a letter to the judge that I think is that I thought was pretty good. I don't know if he thought it was relevant or not, but I said, FOIL does not require that the party requesting records make any showing of need, good faith, or legitimate purpose. However, I wanted to relay to the court that the requests made are in the public interest. My primary intent in requesting the data is to be able to compare apples and apples so that the determinations can be made on the same set of data. If I can get the data before bar, I may be able to determine that the assessor is correct and the taxpayer's concerns are ill-founded. In that case, we'd not need to waste the time of the bar, myself, or the taxpayer, or actually ultimately at SCAR. If I find errors, the assessor should be glad to make it right, as getting assessment right is the job they've been entrusted to do. What is also important is that the assessor be transparent in their efforts. My current impression is that the city has been paid by the taxpayers to assess properties properly. That has not been done. The revaluation has not been done in 25 years. The equalization rate is an unacceptable 62.5%. And the city is spot assessing, which creates unequal assessments all over the city. And the city assessors routinely, selectively assess properties. It's illegal. When you are paid to do a job and you don't do it, it's called fraud. Contractors that take money to do a job and don't do it go to jail. It is also important that the data be public to protect against criminal activity such as assessor kickback schemes. We need to go no farther than Rochester to see assessor corruption exists. And I provided a link to a story about the case that happened in Rochester. The assessor and an appraiser arranged a scheme to puff assessments, get the appraiser to come up with a lower figure, and they split the proceeds to the tune of millions of dollars. So they had an inside guy at Kodak and other companies apparently as well, and the assessor would raise the assessments. The Kodak guy would hire this appraiser. The appraiser would come up with a lower figure. The assessor would agree to it, and then Kodak would pay the appraiser a percentage of the savings, and then the three of them would split the proceeds to the tune of millions of dollars. And they got away with it for years. If the data was required to be available, these people would not dare do what they did. As it turned out, they were caught after the money was spent. The assessor and appraiser died in jail. So there was a little bit of justice there. They defrauded Kodak, Global Crossing, ITT, RG&E, and Bosch and Lomb, others, and the public. The Kodak case was peanuts compared to the 35-year New York City assessor kickback scheme, which at the time was the largest municipal fraud in history. And I provided a link to a New York Post story on the matter. It was they were arranging kickbacks for the biggest buildings in Manhattan. 18 New York City assessors, actually 16, were indicted. I think a total of 18 people were indicted. A scheme run by a retired assessor that arranged reductions for kickbacks on the largest buildings in Manhattan. If the data was available to the public and the government watchdogs, they'd be less likely to think that they could get away with that fraud. And they did it for 35 years, basically supplementing the income of the entire assessment department. It is in the public interest that the City of Syracuse assessment department be completely transparent. They work for the public. They need to provide data when requested with full cooperation. I request a determination as quickly as possible so that the taxpayers can get their data for this year's assessment review at Bar and Scar starting in February. And subsequent to my having written this, it was found out that the city had not had given an exemption for a high-rise building to the tune of $70,000 of taxes that the rest of the taxpayers had to absorb because the city was negligent in providing an exemption when it didn't qualify for an exemption. And that's just one case that the Syracuse newspapers found. There's probably dozens, perhaps hundreds of cases where these people have screwed up, but they won't allow the data, so nobody can figure it out. But and that's got to change. So anyway, the decision is at the bottom, and let me see here if I can find the actual order. Yeah, the hearing officer. Let's see. Failure of the assessor to save the comparable sales report used in rendering an assessment, while not necessarily constituting a violation of public officers law, any person who, with intent to prevent the public inspection of a record pursuant to this article, willingly conceals or destroys any such record shall be guilty of a violation. Certainly frustrates the public's access to the record admittedly used in reaching that assessment. Having admittedly used the comparable sales report in rendering the assessment and subsequently deleting the same, requiring Assessor Oja to create that record in a situation where any programming necessary to retrieve a record maintained in a computer storage system and to allow the transferred record to be read or printed shall not be deemed to be the preparation or creation of a new record. So, therefore, the court finds that the respondents have failed to comply, respondents being the City of Syracuse, with the FOIL request for the comparable sales report requested for 7 Battle Road in the City of Syracuse, and the respondents shall program the New York State real property system to recreate the comparable sales report that was used in admittedly rendering the assessment of the same. And the court has considered the remaining requests for relief by the petitioner and found them to be without merit. And that was I asked for costs and so on and so forth, and I asked for that injunction. The injunction I can understand. Cost I should have been given, in my opinion, but usually, the case was convoluted, and they can plausibly say that they didn't know or whatever, and so they're not going to give me costs. Although I think I substantially prevailed, and I should be due at least the costs. I'm not an attorney, so they're going to say I can't get attorney's fees, but when I routinely beat these attorneys, why shouldn't I be paid what it is that they are paid, in my opinion. But moving forward, if they evade this order, I believe that I'll be due costs at that time. But again, you can find this entire case in the New York State e-file. And the things that I find particularly interesting is read the petition, and there should be a let me see here. My affidavit or affirmation in reply is good. Yeah, both of those, and my memorandum of law in opposition, I think is pretty good. I think that's. Let me see how many pages. It's 8 pages. There's a bunch of word count rules and things of that nature you have to abide by, and it has to be certified. I'm sorry, it has to be notarized. Okay, here's a certification to the word count. Let's see. Preliminary statement. And I stated here, as succinctly stated by John F. Kennedy, the very word secrecy is repugnant in a free and open society, and we are, as a people, inherently and historically opposed to secret societies, to secret oaths, and to secret proceedings. We decided long ago that the dangers of excessive and unwarranted concealment of pertinent facts far outweigh the dangers which are cited to justify it. I thought that was pretty good. Respondents' overall logic makes no sense and contradicts itself because the respondents are comparing apples and oranges, perhaps most glaringly in their flawed analysis of General Motors versus Town of Messina. And in said case of property at issues, General Motors parts manufacturer. In the instant matter, subject properties are residential. In Messina, the property owner requested municipalities' third-party consultants' data. So what it did was it came down to their case law versus mine. Mine was Eckel versus Nassau County, which is about 2-year-old case law, versus the irrelevant GM case from 1998. And I think that was the bottom line. But read the decision. But you can look up any case, and search by attorney or by petitioner or by whatever. And if you're interested in hiring an attorney, you can research their cases and see how they did. And it's a great tool, New York State Unified Court System, electronic filing. So just Google NYS e-file. Again, this is Mike Franklin, the property tax guy.